as we mark this milestone, 20 years of freedom, not only reflect, look at the past for its own sake, but for the sake of the future, to ponder whether we've learned anything that can guide us towards the next decade of freedom. As we all know, 1994, the democratic breakthrough was a culmination of a long struggle that started right at the onset of the 20th century, inspired by non-racialism, equality, and the universality of humankind. Throughout the course of that 20 years, a whole lot of other ideas were incorporated into the struggle. Among them are social justice, gender equality, to a point where our struggle became the first struggle, national struggle in the 20th century to assume an international character. That itself was testament to the progressiveness of the struggle. And those ideas, of course, were put into paper. Policies were formulated, policies that would guide the post-apartheid South Africa to translate the ideas into reality. However, the very fact that our transition was a negotiated transition meant that compromises had to be made. Ideas and wishes that had been envisaged in the course of struggle would not necessarily come to life. A compromise, by its very nature, it means give and take. Certain things had to be deferred for a later date, whilst others assume agency. And the conditions within which we got that liberation was not of our own making. Certain things could not. Conditions both nationally and internationally. So the idea, therefore, is that this conference try to understand why certain things happened and others did not happen. A lot of things have emerged in the course of this post-apartheid period. Things that have to do with institutions, society, and of course, leadership. So the purpose of our reflection, therefore, here is to see how we use the past to guide our future, and then decide where to from here. These are important issues that our esteemed panel will ponder upon. We have gathered here throughout today and tomorrow esteemed individuals, jurists, actors, bureaucrats, and policy wonks who will share their insight with us. And of course, it's a conference. By its very nature, a conference of this nature is quite critical. But before we ponder these important matters, as custom demands, I think Professor Murray will come in front and give us the warm UNISA welcome. Professor Murray.
Thank you, Program Director. Dr. Silebetsu Mukoni Matabane, the Deputy Chairperson of UNISA Council, members of the UNISA Council present, members of UNISA Executive and Extended Management present, the Honorable Justice Dikgang Moseneke, Deputy Chief Justice of the Constitutional Court of South Africa, and other members of the judiciary present, members of the diplomatic corps present, former cabinet ministers present, Dr. Frini Jinwala, former Speaker of the National Assembly of South Africa, who will be joining us shortly, members of the International Tamale Advisory Committee, members present, executive mayors present, members of the Thabo Mbeki Foundation and Board of Trustees present, members of management of MISTRA present, Board and management of Tamale present, invited members of the media present, distinguished members of the audience, ladies and gentlemen. It is a great privilege and honor for me to be here and to welcome you formally to UNISA. Let me start by thanking the organizers of this important conference, the Mapungubwe Institute for Strategic Reflection, MISTRA, and the Thabo Mbeki African Leadership Institute, TMALI, here at UNISA, for their timely initiative, sense of history and foresight. The spirit of the cooperations that the two institutions have demonstrated in the process of organizing this conference must be commended, as it is worthy of emulation. This conference comes at a critical juncture in the life of our fledgling democracy. 20 years ago, the dark cloud of minority rule was lifted over South Africa. In what passed as the most unique, sophisticated, and ingenious transition from settler colonialism to majority democratic rule, South Africa came out of the ruins of racial conflict, intense violence, mutual mistrust, and an uncertain future to a constitutional democracy that laid the basis for a non-racial, non-sexist, and prosperous society, as the Constitution says, and may I add, a non-discriminatorily plural society. Over the last 20 years, several actions have been taken to redress the injustices of the past and build a harmonious, prospective, and progressive society. Although many milestones have been reached in meeting the needs of the people, challenges remain. In an attempt to find solutions to these challenges and provide retrospective and prospective analysis of the centrifugal and centripetal forces that affect the delivery of dividends of democracy, that a conference such as this one becomes very apposite and germane for the future of our country. I gather the conference also provides an opportunity for reflection on the historical moments that led to the democracy in South Africa, particularly the difficult and tortuous negotiation process. It is also fitting that the conference also rested with important questions that relate to the creation of a democratic developmental state and strengthening social cohesion. It is commendable that the conference also problematizes the notion of the Africa Rising narrative and also examines the global economic context. In view of the current realities in the socio-economic spheres, there are pertinent questions that people are asking as to the nature of the negotiations, the determined forces and compromises reached. The objectives are to enhance our understanding and facilitate concrete remedial action towards forging a more progressive and inclusive society. This conference will also deal with the important area of the political economy of South Africa. There is a view that over the last 20 years, South Africa's political economy has been defined by the paradox of growth, stagnation, and near recession. Although the National Development Plan articulates a vision for the country and the path towards a truly democratic, non-racial, non-sexist, and prosperous and equitable society, questions remain as to how adequate and appropriate is Vision 2030, absence or presence of capacity and will to implement the vision, and what are the implications of what appears to be increasingly weak economic performance. It is indeed important that the conference provides opportunity for debate and discussion around the challenges facing South Africa and how to arrive at the desired destination of a prosperous and inclusive economy. Contemporary globalization has ensured that the whole world is interconnected more than ever before in human history. What happens in the remotest part of the world can be transmitted to other parts of the world at the speed of light. It is in this light that South Africa is not immune from the global economic crisis that ravaged the world from about 2007. Although some would want us to believe that the effects of the crisis on the country was minimal, it is now clear to all that the global economic crisis had wide ramifications in many ways, and sectors whose impact is yet to be fully felt. The effects of the global economic crisis and the paradox of growth without development that has given rise to the new narratives of African rising, and it deserves serious intellectual analysis and scrutiny. As the various panelists and paper presenters engage with the pertinent issues in the course of this very timely conference, it is my fervent hope and expectation that the outcomes and the deliberations will provide policy direction for our government in a way that can lead to a better South Africa and Africa in general. Once again, I want to thank the organizers, and I wish you fruitful deliberations. UNISA is proud to be associated with this important initiative and other similar ones. I'm also told that our students and the wider UNISA community would have an opportunity to interact with members of the Tamale International Advisory Committee this evening. I'm sure this will be insightful. Ladies and gentlemen, I thank you and I wish you the very best. Thank you.
Thank you to the Vice Principal Academic, Professor Murray. Must say I was impressed that in her remarks she used the phrase settler colonialism. Especially impressed because of her last name. That's a term that is not normally used because it is indictful. It poses a lot of questions that remain unanswered. We are honored, ladies and gentlemen, to have amongst our midst our keynote speaker, Deputy Chief Justice Dikgang Moseneke. I trust we all have this brochure in front of us, so I will not read the entire biography. Safe to say that our keynote speaker is a man of distinction whose life has struggled multiple spheres, beginning as a political activist from a very young age, for which he was imprisoned for many years at the island as 18, where he started studying towards a law degree. Upon his release, continued to study and became an advocate, ascended to the bench, had a stint in business and realized that perhaps judiciary was the most important part. Went back to the judiciary, and he is now a jurist and a scholar. Please join me in welcoming Deputy Chief Justice Dikgang Moseneke to the podium.
I must at the outset confess to a frog in my throat. I truly apologize, and I hope you'll bear with my rather struggling voice, and the cause is the usual common flu. I'd like to greet all distinguished people of our country and those who are visiting us. I'm grateful to be here rather than in court this morning. The court is sitting, and I've bunked court for this. I owe gratitude to Mapungubwe Institute of Strategic Reflection, the Thabo Mbeki African Leadership Institute, and special thanks to this, my alma mater, and the only university I've ever attended, from which I acquired no less than 3 degrees during my short stint of 10 years on Robben Island. Yes, 10 years can only be a short stint if one remembers that our departed and beloved leader, Nelson Rolihlahla Mandela, was there for 27 years, and Comrade Kathrada was there for 24 years. I've been asked to reflect on our constitutional democracy with a slant on transition and transformation. This I propose to do by looking at the past 20 years only fleetingly, in order to proffer reflections on our collective future. Our hosts have urged that our dialogue in the next 2 days should be not diagnostic, but rather prognostic. The thematic conversations of this conference seem to require of us not to analyze the past until we are hypnotized, but rather to probe the future. As Lenin famously asked, what's to be done? Appropriately, we have been counseled to dwell in the past only so that we may thoughtfully pose the question, so where to now? This conference will be reflecting on selected trends and features of our democratic project. I hope not to venture into alleged terrains of distinguished leaders, scholars, and other thinkers who are here present and who will be serving in panels. Therefore, I will not recount historical moments, nor dabble in the discourse on our political economy, or even get anywhere near the African economic renewal, let alone the global economy. There are others better suited to that task. Similarly, I won't debate values, nation formation, and social compacting, nor will I venture into a discussion on innovation, transdisciplinary knowledge, or the prognosis of a developmental state. These matters will enjoy the attention of very distinguished contributors. I propose to stick to my knitting. I must remind myself that although I'm a child of our revolution for a just society, I'm a sitting judge in service of all our people and their democratic state. It behoves me to speak, therefore, like a judge, a role I've played so long that it now feels like there's the only thing I've ever done in my life. I will describe briefly our transition and the normative scheme of our democratic enterprise. Next, in broad brushstrokes, I will depict what the transition has yielded. Being a judge, I will catalog what the courts have done in the 2 decades of transition, albeit very briefly. I will then turn my lens onto 4 selected features of our democratic project that pose trenchant challenges to this project. These challenges, I think, deserve our careful reflection as we, patriots, ask what's to be done. The first of these challenges is the land question. Here I'll be probing whether the democratic project has secured urban and rural land justice. The second issue flows from the first. It is the vexed terrain of achievement of equality, non-racialism, and restitution. In the third instance, I'll ask questions about the impact of concentrated executive power on our public institutions. And lastly, I'll reflect on mediation and adjudication of public disputes. Well, let's get on with it then. Let me start with a touch of patriotic vanity. In the wake of the Arab Spring, a U.S. Supreme Court Justice, Ruth Bader Ginsburg, whilst visiting Egypt, was asked to provide advice on constitution making, something Egypt sorely needed. I would not look to the United States Constitution if I was drafting a constitution in 2012. She recommended to the Egyptians to look, in her words, to the South African Constitution and perhaps the Canadian Chapter of Rights and Freedoms and the European Convention of Human Rights. A fascinating law journal article titled The Declining Influence of the United States Constitution, penned by two American law professors, bemoans the decline of American constitutionalism around the world. The article reports on an empirical study of constitutions of the world and finds that 4 constitutions are influential benchmarks for modern constitution making. It lists constitutions of, foremost, South Africa, followed by Canada, then Germany, and then India. So we can afford to be gentle on ourselves. We've managed our post-conflict arrangements better than we grant ourselves. We need not beat ourselves too hard. Our constitutional democracy was forged on the anvil of division, past injustice and economic inequity, but also on the hope for reconciliation, for nation building and social cohesion. So notionally, our constitution is premised on the will of the people, expressed in representative and participatory processes. It does not only establish its supremacy, rule of law, fundamental rights, but also recites our collective convictions. It contains our joint, if not minimum, ideological and normative choices of what a good society should be. It enjoins the state and all its organs to take reasonable steps without undue delay to achieve that good society. The virtuous society envisioned has a significant social democratic flavor, some reckon, and yet others take it to be no more than a neoliberal compromise. Aside all these facile tags, the Constitution provides for many progressive things. It protects and advances fair labor practices. It compels all to preserve an environment that is not harmful for the benefit of present and future generations. It envisions restitution of land to victims of dispossession, but does not permit arbitrary deprivation of property. Our Constitution permits expropriation and redistribution of land for public good, provided it is against just and equitable compensation, a matter to which I'll return in a moment. The envisioned society sets itself firmly against poverty, ill health, ignorance. This it does by promising everyone the right to have access to adequate housing, health care, food, water, social security, subject to available resources and progressive realization. It reminds us that a child's best interests are of paramount importance in every matter concerning it, and everyone has a right to basic education, including adult basic education. The Constitution enjoins and hopes for an effective, responsive, open and accountable governance from all organs of state, inclusive of Parliament, the executive and the courts. Parliament, it tells us, must make laws. It must hold the executive accountable and provide a forum for debate on matters of national importance. It tells us that the executive must implement laws, make policy and spend fiscal allocations. Courts must resolve disputes in accordance with the Constitution and the law, which includes African indigenous law and the common law. It must follow from what I have said that our constitutional design is emphatically transformative. It sets itself the task to rearrange power relations in society. It is meant to migrate us from a murky and brutish past to an inclusive future animated by values of human decency and solidarity, if you will, values of Ubuntu. It contains a binding consensus or a blueprint of what a fully transformed society should look like. But then what has this transition yielded? We are indeed dismantling racial domination, or settler colonialism, if you like. We have managed a treacherous transition and set up ground rules that underscore our democratic ethos, public morality, and governance. We have established and maintained a functional democratic state with all the customary markers, including multipartyism, regular elections, the rule of law, and separation of powers. Our parliamentary system functions, certainly more at an elective than at a participatory level. Our fiscal and state treasury functions are not shabby, and our revenue collection is world-class. Our courts are independent and effective. Our Chapter 9 institutions, to name a few, the Auditor General, the Electoral Commission, the Human Rights Commission, and the Public Protector, have teeth and quite often bite. We boast of a robust civil society that takes up social causes around just about every social issue. For instance, campaign on HIV/AIDS and access to medication, on genderized violence and on access to textbooks and education. For good measure, one may add the Pooh protest campaigns in the Cape, widespread opposition to e-tolling, objections to the use of labor brokers, and the campaign on the right to know. We have our more than fair share of open and public dissent and street protests amongst marginalized people. We are blessed with a vigilant labor movement, a free press that is prying, that is fearless, and often unbending. None of our citizens have been jailed only for political, religious, or other beliefs. Put simply, we have no political prisoners in this country. We are not pitted against each other in a civil war, or a genocide, or terrorist attacks. Our transition has indeed yielded much. If you think there is an overly rosy picture of our democratic transition, I urge you to suspend your judgment until I finish. I will shortly debate future challenges to our democracy. What value has been added in all this process by the courts in particular? That's where I work, so I will talk about that. In many senses, our courts have been remarkable. Shortly after our transition, equality and discrimination cases proliferated. In a series of notable cases, courts have refused to tolerate inequality and discrimination. We have struck down scores of laws that undermine appropriate respect for diversity or that harbored antiquated prejudices. Amidst many rumblings, courts would not tolerate, for example, homophobia or gender inequality inspired by cultural patriarchy. We have fashioned the notion of a substantive justice that travels well beyond liberal notions of formal equality. We have insisted that laws and policy must provide for adequate protection of children, root out domestic violence, people with disability, and refugees as well as migrants. Courts have time without count required the executive to give effect to socioeconomic claims for the poor and the vulnerable. We have required government to provide access to health care. Happily so today, our jurisdiction is arguably one of the best public treatment regimes of HIV/AIDS patients. We have reminded the executive of its duty to provide access to housing and have ordered it so. We have mediated differences around rampant eviction of the homeless, urban and rural occupiers who are said to be unlawful. We have insisted that landowners must display patience as homeless occupiers find other places of refuge. Often we have ordered municipalities to engage meaningfully with communities in order to avert inhumane evictions. We have ordered government to find alternative accommodation should evictions ensue. Courts have insisted that drinkable water be made available to vulnerable members of society. We have protected learners from being subjected to medium of instructions they don't want. We have required that learners be furnished with study materials. Courts have required social grants to reach all, including vulnerable migrants, and that grants be paid promptly, particularly in rural neighborhoods. Our courts have developed a very proud jurisprudence on justice at the workplace. That is a consequence of vital choices our founding mothers and fathers have made on worker rights, the recognition and formation of trade unions and employer organizations, and the resultant collective bargaining and fair labor practices. Properly so, we as courts have refused to sacrifice workplace justice on the back of claims of promised economic growth that a so-called open labor market will bring to us. That may or may not be so, but that is not for judges to decide. Courts are bound by labor laws. Just labor laws are integral to a more equal and caring society, where the dignity of all, including of working people, must be shielded. Courts have been properly preoccupied with the protection of rights to free expression, including a free press and the right to impart and receive information and the arts. Our judgments point to the intrinsic worth of free expression and the many public and private blessings of a free and open and debating society. And yet our judgments have also warned that free expression has limits, particularly when it encroaches on dignity and privacy. However, when public interest is an issue or is an attempt to suppress information, perhaps other more pressing considerations come to the fore. That balance is not generic. It can properly be struck only on a case-by-case basis. Courts have intervened where valid allegations have been made about wrongful procurement of goods and services by government. This is a sequel of the important requirement of our Constitution, that when all spheres of state contract for goods and services, they must do so within a system that is fair, equitable, transparent, competitive, and cost-effective. To that end, Parliament is required to legislate in order to prescribe an appropriate framework for the procurement policy. Of course, the Constitution was alive to the fact that the government procurement practices will be vital in achievement of more equal society. In the same breath, however, our constitutional project is properly inimical to and intolerant to corrupt state tender practices and all forms of public or private corruptions. Courts can only do with prosecutions that come before them. And these, sadly, I must say to you, have been surprisingly few. In the last 2 decades, no criminal prosecution on tender irregularities, misuse of public funds, or related fraud has served before any of our superior courts. The celebrated cases of Silibi and of Sheikh related to private, not to public funds. This begs the question whether there was no misuse of public funds or tender fraud in the last 20 years worth prosecuting. The record shows that when the prosecuting authority have ventured into the courts, my judicial sisters and brothers have not wavered. Competition law has found a niche in our courts also, about which we're very proud. This is admirable. In the past, the economy allowed very little or real competition in the marketplace because of structural and behavior anti-competitiveness. Some of our manufacturing and retail businesses have been found by our courts to have engaged in collusive practice, including price fixing. The Competition Commission and its tribunals have done much enviable to remedy or reduce commercial injustice to consumers that flow from collusive pricing. I tend now to look at 4 chosen areas which I called trenchant challenges to our democratic project. I'll start with the land question. Nearly 70 years ago, in The Wretched of the Earth, Frantz Fanon observed, I quote, "For a colonized people, the most essential value, because it is the most concrete, is first and foremost the land the land which will bring them bread, and above all, will bring them dignity. The quote ends. Fenon's remarks were apt, but not a new insight. If one remembers that the organizing principle of the formation of the African National Congress in 1912 was the impending wholesale land confiscation prefigured in the 1913 Land Act. Land dispossession, coupled with urban spatial apartheid, led to immeasurable social devastation recorded in many valuable studies. The land question was foremost at the time of the formation of the Constitution. This is displayed in the careful formulation of the property clause, which is often more maligned than carefully scrutinized. Let us quickly look at the scheme of our property clause. I start with land restitution. The section envisions restitution of land to victims of dispossession, but does not permit arbitrary deprivation of property. A person or community dispossessed of property after June 1913 by racial discriminatory laws is entitled either to restitution or equitable redress. Similarly, a person or community whose land tenure is insecure because of apartheid laws is entitled to receive secured land title. And commendably, Parliament passed the legislation to give effect to land restitution within 12 months of the democratic rule and established a dedicated land claims court. Returning to the property clause, it permits expropriation of land by law of general application, provided it is for public purpose or it is in the public interest. And this may be done against just and equitable compensation, reflecting an equitable balance between the public interest and interests of the landowner. The extent of the compensation may be fixed by agreement or by a court, guided by a number of listed factors in the Constitution itself. But I thought this morning I would like to slaughter a few shibboleths. The Constitution does not protect property. It merely protects an owner against arbitrary deprivation. Deprivation that is not arbitrary is permissible. The property clause does not carry the phrase willing buyer and willing seller, which is often bandied around and blamed for an inadequate resolution of the land question. The state's power to expropriate does not depend on the willingness of the landowner. The compensation may be agreed, but if not, we, the courts, must fix it. The compensation must be just and equitable, and not necessarily the market value of the land. Market price is but one of 5 criteria that our Constitution lists for a court to set fair compensation. The property clause is emphatic that the state must take reasonable measures within available resources to enable citizens to gain access to land on an equitable basis. The cutting question is whether democratic consolidation has achieved urban or rural land equity. Although much has been done, the answer, regrettably, is no. Present statistics on land distribution show very little movement away from the apartheid patterns of the use and ownership of land. Only a small percentage of land restitution claims have been finalized. The bulk is yet to reach the courts or be settled. Land claims that do reach the courts display remarkable delays of years before reaching the courts. The claims are also beset by bureaucratic inadequacies, and there are severe difficulties for claimants in gathering evidence to back their claims and to overcome the legal resistance of owners who litigate against claims quite often. On another front, there is a very scant evidence of the use by the government of expropriation to achieve land equity. In 20 years, our court has not resolved even one case of land expropriation under the property clause by the government for a public purpose. Similarly, in the same 20 years, courts have never been called upon to give meaning to the property clause in the context of land use, control, and enjoyment, or to decide on what is a just and equitable compensation. One would have expected that a matter so pressing as land use, occupation, ownership would predominate the list of disputes in our post-conflict contestation. Sadly, urban homelessness persists, though much has been done. Apartheid spatial patterns remain. People in informal settlement run the risk of mass evictions, such as we have seen lately in Luanda, in the Cape, also more recently in Cato Crest, in KZN, both of which were mounted by local government. Rural land hunger stands in the way of genuine rural development. Women who till the soil and live on communal land don't have the protection that security of land tenure provides. Communal land vests in traditional authorities who do not always act in the best interest of their communities, made up mainly, for reasons you know, of women and children. In at least 2 cases relating to platinum-rich Limpopo and Northwest provinces, our court had to intervene where the traditional leaders had concluded arrangements on communal land relating to mining. It may be that the property and restitutory provisions in Section 25 of the Constitution on land have been hopelessly underworked, and I think so. I want to suggest that we cannot talk about transformation or of social justice or of cohesion when urban and rural land injustice dominates the lives of the majority of our citizens. Millions will continue to live in desperate and undignified conditions unless we confront land inequity. Next, I want to look at equality, non-racialism, and restitution. The achievement of equality is a founding value of our Constitution, and is said to be the most prominent organizing principle of our democratic enterprise. And yet, reality is starkly different. Several socioeconomic measures suggest that we are, as we all know by now, the most unequal society on the globe. Lately, the World Bank study compared us with 11 middle-income countries and concluded, and I quote, "However, even with a progressive tax system, inequality in South Africa was still higher than the other 11 countries in the sample. This was because it was one of the most unequal countries in the world." The code continues, "Even though South Africa has a very effective use of its fiscal tools, the original problem in income inequality are so high, original problems in income inequality are so high that South Africa is going to need other things to help it address the problem of inequality." The code continues, "To make further progress going forward, South Africa needs to complement its wonderful fiscal policy with higher, more inclusive growth that essentially generates jobs, especially at the lower end of the distribution." The code ends. I must immediately add that the study commended our state for the way it has used fiscal tools to reduce poverty. The study suggests that 3.6 million people have been lifted above the poverty datum line. The use of social grants has also lowered the Gini coefficient on income, which measures inequality. The World Bank update talks about, if you've listened carefully, the original problem in income inequality, and thus South Africa is going to need other measures to help reduce inequality. That historical inequality of both income and wealth, we know, still persists. and race and gender in most instances are markers of past exclusion or disadvantage. In order to address historical disadvantage, an equality clause in the Constitution permits legislative and other measures to achieve equality. These are restitutionary measures, sometimes inappropriately called affirmative action measures. The two most prominent examples of such measures are employment equity and black economic empowerment laws. At the turn of 2 decades of our democratic project, there has been an increasing discourse about the appropriateness of restitutionary measures within a democratic project that prides itself on non-racialism, non-sexism, and an inclusive arrangement. As I understand the one end of the argument, there's an inherent tension between the requirement of equal protection of the law and of non-racism on the one end, and affirmative action measures which are intended to benefit previously disadvantaged and vulnerable groups. The argument is that race or gender is not always a useful and accurate marker of past disadvantage. The further point is made that young people born in 1994 have no business to look to affirmative action measures because they did not live under racial disadvantage. And in any event, many middle-class black youth, it has been argued, have been as advantaged, if not more advantaged, than many white youth. In certain quarters, employment equity and other related matters are considered to be reverse racism. There is indeed force in the argument that mere race or gender may not be an accurate index of social exclusion and disadvantage. We know that one of the trophies of the national democratic phase of our transition is that the African middle class has shot up from 1.8 million to 5.7 million. That may indeed appear to be an indicator of a more equal society until one locates 5.7 million black people within the middle class within a population of 52 million. Then the black middle class peters out to a mere 10% of the population. Of course, there is an inherent tension between transformative goals based on race and gender in the face of a constitutional value of non-racialism and non-sexist equality. It is necessary that legislation and executive action must be limited to the permissible ameliorative measures that fall strictly within the carve-out created by the Constitution itself. Constitution clearly permits legislative and other measures to promote an achievement of equality, and those provisions of the Constitution remain valid and must be given effect to. But the measures must be designed to protect or advance persons disadvantaged by unfair discrimination. The measures may not amount to quotas. Those people may not be kept out only because they are not black. They must be applied rationally and only to procure a more equal society. They are not an instrument of vengeance, but an instrument to achieve equality. In the second 20 years of our democracy, we'll have to think carefully whether measures in this class will continue to be justified. This is so because fewer and fewer people will be able to claim legitimately that they have been disadvantaged by unfair discrimination of the past. For now, the measures do enjoy constitutional protection because the Constitution permits restitutionary measures in so many words, and our transition needs transformation. The time may not be far off when the national psyche may not be able to tolerate the notion that class interests may very well supersede interests forged only around race, gender, and past disadvantage. A last point has to be made. The most effective way of confronting past disadvantage must lie in broader socioeconomic transformative agenda of our society. In a non-racial way, we must strive for an equal and socially just society. We must harness public resources carefully and sparingly and honestly towards quality education. We must develop entrepreneurial capabilities, better health care, access to housing. For instance, fiscal interventions have funded social grounds for all vulnerable people, irrespective of their gender or race. To conclude, our constitutional desire permits ameliorative or restrictionary measures, and courts are obliged to give effect to them. And yet, I pose the question whether race-based transformation continues to be consistent with our broader constitutional transformation. Many transformative projects in the Constitution, and in particular its socio-economic guarantees, are not race-based and need not be. That, I suggest, is another challenge for the next 20 years. I look now very briefly at executive power and public institutions. Much of the glowing talk about our constitutional architecture relates to fundamental rights and freedoms. And yet the manner in which public power is allocated within the Constitution is not always optimal for advancing our democratic transformation. I suggest that in the next 2 decades, we may have to revisit the dispersal of public power. Because of time and space, I will limit this discussion to the national executive. Of course, amending executive power may be a difficult task that calls for an amendment to our Constitution. Much as the Constitution is premised on the principle of cooperative government, binding the national, provincial, local spheres of government, a careful examination of powers of the national executive in Chapter 5 of the Constitution and in other legislation displays a remarkable concentration of power in the President, and in particular, the President's powers of appointment. In a few instances, the President exercised these powers of appointment together with Parliament and other organs of state. As for the rest, the President appoints within her or his exclusive discretion. The anecdotal account is that at the time of the formulation of the final Constitution, and then the President was Mr. Nelson Rolihlahla Mandela, whenever there was a dispute about who should appoint a public functionary, the negotiating parties were happy to leave the power in the hands of a incumbent, Nelson Rolihlahla Mandela. He, after all, will do no wrong. In a footnote, I have rehearsed a complete catalogue of the President's powers of appointment. I refer to a few now. Unlike in other countries where the Deputy President is a running mate, here he is appointed by the President. This means that he or she may be dismissed summarily by the President. And our history has shown how the dismissal of a Deputy President could be deleterious to the executive function, if not to the nation as a whole. The President appoints ministers of the Cabinet and deputy ministers. That's pretty usual and normal. But he also appoints leaders of government business in the National Assembly. I'll use he for now, without being gender insensitive. He appoints all ambassadors. The President appoints the Chief Justice, the Deputy Chief Justice, after consultation with the Judicial Service Commission. The President appoints the President of the Supreme Court of Appeals. He also is also empowered to appoint judges, President of the Land Claims Court. He appoints the Chairperson of the Competition Tribunal and the Judge President of the Competition Appeal Court. He appoints all judges on advice from the JSC and acting judges in consultation with the Chief Justice. The President appoints heads of many vital institutions in our democratic enterprise. These include the National Director of Public Prosecutions, the Public Protector, the Auditor General, members of the South African Human Rights Commission, the Commission for Gender Equality, the Electoral Commission on recommendation of the National Assembly, and may remove members of Chapter 9 institutions on specified grounds. The President appoints the Commissioner of Public Service Commission, the head of the Defense Force, and the military command of the Defense Force, the head of the police, the head of the Intelligence Service, and members of the Financial and Fiscal Commission. And under a variety of legislation that is outside the Constitution, the President appoints the Statistician General, the Governor and the Deputy Governor of the South African Reserve Bank, the Commissioner of the South African Reserve Services, the Revenue Services, I beg your pardon, members of the Tax Court, members of the Independent Communication Authority of South Africa, ICASA. As you would expect, all these powers of appointment are coupled with powers of removal, albeit subject to some prescribed process. Now, the vast powers of the appointment of the National Executive bring to the fore the debate whether the democratic project is best served by a powerful central executive authority. Our courts have had occasion to adjudicate challenges against the rationality of several appointments made by the President, and generally an uncomfortable task. It is self-evident that an appointment by a deliberative collective is less vulnerable to legal challenge of rationality than appointment by an individual functionary. The ultimate question is how best we may shield appointments of public functionaries to institutions that gird and underpin our democracy from the personal preference and vagaries of individual with power to appoint. The question may be asked differently. How best must we safeguard the effectiveness and the integrity of public institutions, which are indispensable to our democratic polity? Finally, an equally important debate should be whether appointing members of the cabinet exclusively from the ranks of members of parliament best advance the duty members of parliament have to hold the executive to account. If their logical career advancement is within the national executive, are members of parliament likely to rattle the executive cage? Will they fulfill their constitutional mandate by holding the national executive to account? This uncanny concentration of power is a matter which, going forward, we may, as a nation, ignore, but only at our peril. The final matter I'd like to look at is conflict resolution within our society, and I promise that I'll sit down. Adam Perzeworski is a Polish scholar in politics and democracy. He says democracy is the realm of the intermediate. The future is not written, he says. Conflict of values and of interests are inherent in all societies. Democracy is needed not to pass power to others, but precisely because we cannot agree. Democracy is only a system for processing conflict without killing one another. It is a system in which there are differences, conflicts, but there are also winners and losers. Conflicts are absent only in an authoritative system, the code ends. Statistics on the number of public protests, some of which tend to be violent, is startling. In the last 12 months, the police have reported in their own official website 11,688 service deliveries or protests in our country. It is fair to consider public protests as a dispute resolution mechanism, which is readily available to working and marginalized people. Some protests do indeed yield the desired results because officialdom sometimes does listen. Other prospects come to naught. A trend not unlike civil protest is a contestation that occurs in the rarefied setting of a courtroom. Litigation in our country too has become a preserve of those who wield public power and purse, and those who can afford litigation out of their available resources. The ever-bulging court roll at the Constitutional Court tends to be dominated in the foremost by state litigants, followed by business enterprises, and followed by labor disputes. All three classes of litigants are funded by a collective purse. A trickle of disputes is prosecuted by public interest law firms for vulnerable classes of citizens. The result of all this is that superior courts of our country are confronted by an avalanche of litigation from powerful interests in the land. The phenomenon is known by some legal theoreticians as lawfare. War through law, lawfare. In the past, law has of course played an important role in our history. Apartheid oppression was itself a collection of laws which were harnessed to achieve unjust economic and political ends. However, in the eyes of the majority of the people, there was no real divide between law and politics. And often there is no real divide. Law served narrow political ends, and courts were seen as mere instruments. In the process, the legitimacy suffered and waned. Activists prosecuted spirited political struggles in the courts and through the law. And activists too used courts and the law to proclaim their revolutionary causes. This point is made rather sharply by Dennis Davis and Michel Leroux in a fascinating book called Precedent and Possibility. They say during the long night of apartheid, courts were often sites of vigorous political struggle, being places where different visions of the country were presented to the public by competing litigants, usually the state against accused persons, or applicants whose rights were at stake. However, since 1994, they say the advent of constitutional democracy, similarly significant contests have taken place in the courts. There's, however, a major difference. Litigation now takes place in the context of a constitution which provides a vast range of rights for all who live in the country. I want to suggest somewhat differently. Despite the advent of democracy, the tide of litigation has not dried up. South African courts have particularly of late been confronted with a series of challenges which turn on a variety of disputes. Some are essential of a political nature. The termination of the Scorpions, its replacement by the Hawks, the extension of the office of the Chief Justice, the appointment of Judge the Cape Court, the appointment of the National Director of Public Prosecutions, the challenge into the arms deal which finally led to the appointment of the Commission of Inquiry, a parliamentary dispute over motions of no confidence, powers of the public protector, appointment battles within state enterprises, and whether or not they have qualifications that they claim. The labor movement itself resorts to the courts, often to resolve internal schisms and contestations. Courts adjudicate routinely on disputes arising from state tenders. Indeed, a plethora of business claims land in our courts, whether it is about collusive trading or price fixing or tax assessments or forex claims, such as the case before us of Mr. Shuttleworth versus the Reserve Bank. but in the front row of litigation is our democratic state. This excessive use of the courts speaks to the concern that democratic arrangements in our land are virtually devoid of non-litigious sites for mediation of conflict. Why would party faithfuls rush off to court to resolve an internecine disputes? Why is the state the chief of all litigators, certainly in our court? How does it happen that labor federations should seek solace in us judges calling it for them? It is not unusual to hear activists or senior politicians vowing to go to the Constitutional Court. I heard one only this morning saying so on radio. Now, Dennis Davis suggests that this trend is primarily owing to a manifest failure, perceived or real, of the political processes of our land. When politics fails, the last and often only avenue left to affected parties is to proceed to court. The more this trend continues, I want to suggest, the more the courts will be drawn into disputes that should not properly be before them. But courts are not and should not be a substitute for the obligation to move our society to a space envisioned by the constitutions. Courts cannot achieve a realignment of power relations in our transformative society. We must rethink our democratic process in a manner that permits peaceable conflict mediation away from litigation. We must find a new ethos that permits the lamb and the lion to graze together. Losers and winners within the democracy should both be able to feel that they have overcome. Allow me at this stage to recall profound words as I conclude, written by Achille Mbembe on much the same topic. He was writing in a piece called Forward to an Inconvenient Youth. He wrote, "A gradual closing of life chances for many, an increasing polarization of the racial structure, a structure of indecision of the heart of politics itself, and a re-balkanization of culture and society. These trends clearly undermine the fragile form of mutuality that could have painstakingly built in South Africa over a decade in half, and further weaken the prospects of true non-racialism. Stuck in a field of blighted possibilities, the youth scavenge to live or simply to get through the day. So many bad jobs available to so few in one of the most racially unequal countries on earth, so much rage, and almost in the near future, the quote's end. We in the courts are going to continue manning our posts, serving you and securing the rule of law and just resolution of disputation. But in the end, a just society envisioned in our Constitution will emerge only from truly democratic processes and socially inclusive programs that will let all in, that Mbembe was talking about. I conclude, we have not found a satisfactory solution to spatial apartheid, equitable access to land, housing and basic services. There is no significant rural development that would have stemmed poverty-stricken urbanization. The epicenter of economic power is still vested in monopoly capital. Mineral resources in the past and now do not trickle down to workers and the broader populace. Race is still a marker of social inequality. The income disparity has become bigger and starker. Only a small crust of the black middle class has advanced economically against the backdrop of nearly a third of us on social grants. Another third of our youth unemployed. We must be disturbed that up to now we have not learned how to create jobs for ourselves. After all, a claim to liberty is a claim for space to prosper oneself or one's community, not simply to work for others. It is not happening. Instead, as we know, numbers show poverty is deepening. We have not skilled our children enough to be entrepreneurs and not to be job hunters. Quality education and health care are still only for the financially well-off. I am afraid, I must add, and confess that the proper access to justice is often a function of one's bank balance, with occasional exceptions. We have a lot to do in the next 2 decades. Let me close by giving Frantz Fanon the last word. Each generation, he reminds us, must discover its mission, fulfill it or betray it in relative opacity. And towards the end of his work, he says a government or a party gets the people it deserves. And sooner or later, a people get the government it deserves. I thank you for listening.